Okay, I'm going to start. Thank you.
Great, Anne, can we get started?
You are live.
Okay, great. Welcome everyone to our webinar this afternoon titled Understanding Agency Self-Regulation. I'm delighted to be here and delighted to be joined today by a very distinguished panel of speakers who I'm going to introduce in a moment. I'm Shalini Ray, Associate Professor of Law at the University of Alabama, where my scholarship focuses on the intersection of immigration law and administrative law. I study the immigration bureaucracy. I wanted to, before introducing the panelists, I wanted to say a few words about our theme and offer some examples of the phenomenon that we're going to be discussing today. So when we speak about agency self-regulation, we're talking about measures an agency adopts to constrain its own discretion for prudential reasons, not because they're required to by some law. And so it's a large chunk of the world of agency action, I think could potentially fall under this category. It's interesting to note the differences across regulatory settings, and that's why I think it's so wonderful we have speakers from a wide range of backgrounds today. In terms of examples of this phenomenon, I think there are many. I'm going to offer a couple. So I think in 2019 or maybe 2020, the Commodity Futures Trading Commission Division of Enforcement published an enforcement manual to sort of illuminate, the enforcement process and to answer questions that I think that regulated parties often have about enforcement. And they're not required, to have issued a document like that, but I think it was widely touted as a good thing in terms of rule of law values and was well received. And so it's something, it's an example of the type of action that agency might take even when they're not required to, that structures and maybe constrains their discretion going forward. Another example that is of particular interest to me would be something like immigration enforcement priorities, where through guidance documents, an agency like the Department of Homeland Security offers guidance to line officers about how they should be exercising their discretion. I think later in this conversation, we'll have a chance to talk about those sorts of policies in the courts and recent litigation over enforcement priorities. So I'm going to introduce our panelists, and then we will hear from each of them. So our first panelist is Christopher T. Curtis, who recently retired as the Principal Deputy General Counsel of the Federal Housing Finance Agency, an agency that oversees the safety and soundness of the housing mission activities of Fannie Mae, Freddie Mac, and the Federal Home Loan Bank System, and has been the conservator of Fannie Mae and Freddie Mac since the 2008 financial crisis. At the FHFA, Mr. Curtis managed legal support for the agency's supervision, regulation, and conservatorship activities. He had been the last general counsel of the Federal Housing Finance Board, which had been the previous regulator of the Federal Home Loan Banks, and has also worked in various capacities at Capital One Financial Corporation, the Federal Deposit Insurance Corporation, and the Federal Home Loan Bank Board, which he describes as a more remote predecessor agency of the FHFA. He also had a stint at Covington and Burling. All right, we're also joined by Richard F. Griffin Jr., who is of counsel at the Washington and DC law firm of Bredhoff and Kaiser, where he represents unions, employee benefit funds, labor management cooperation trusts, and individuals. And he also serves as a mediator. He's taught labor law and is the co-author of a leading casebook in labor law with Seth Harris and LaFaso, Charlotte Garden, and Joseph Slater. Prior to joining Bredhoff, from 2013 to 2017, Mr. Griffin was the Senate-confirmed General Counsel of the National Labor Relations Board, overseeing the prosecution of unfair labor practice cases and the defense of the board's decisions in court, culminating in his arguing before the Supreme Court in Epic Systems Corporation versus Lewis on behalf of the board. Before becoming NLRB General Counsel, he served as a recess-appointed NLRB board member from January 2012 to August 2013. From 1983 through his time as his appointment as a board member, he worked in the legal department of the International Union of Operating Engineers, the IUOE. And for a portion of that time, he was the IUOE's general counsel. And we also have with us today, very pleased to say, we have Lyndon Melman, who is a partner at the law firm of Berry, Appelman, and Leiden, which is based in Texas, but Mr. Melman works out of Washington, D.C. He previously served as chief counsel of the U.S. Citizenship and Immigration Services subunit of the Department of Homeland Security and counsel to the U.S. Senate Judiciary Immigration Subcommittee. He serves at his firm on the firm's management committee and leads the firm's government strategies group. He works regularly with U.S. Congress, the White House, and federal immigration agencies. He serves on the advisory committee of the Migration Policy Institute and advises the leading business trade organizations and companies on politically sensitive immigration matters. Finally, I'm delighted to introduce my colleague, Professor Dacre Steele, who serves as an assistant professor of law at the University of Alabama, where she teaches and conducts research in the areas of civil rights, employment discrimination, employment law, labor law, and education law. And she also teaches torts and legislation and regulation. Professor Steele formerly served as a civil rights attorney with the U.S. Department of Education, where she provided legal counsel relating to federal investigations of discrimination involving the nation's school districts, colleges, universities, and state educational agencies. She also served as a mediator for civil rights claims. She previously worked for the U.S. Department of Labor Office of Federal Contract Compliance Programs, where she assessed federal contractors' compliance with employment discrimination laws. Okay, so welcome to our panelists, and thank you again for being here. So we are going to hear from each of the panelists, and we're going to start with Chris Curtis. I do want to remind the panelists that, I am interested in hearing from you, your individual remarks and learning about what forms of agency self-regulation you saw adopted at your agency or agencies that you're familiar with, and interested in learning a bit about what led to the adoption of those measures. What are the incentives to adopt measures like that, and what are challenges that agencies face in adopting those measures? So we're going to start with Chris.
So thank you, Professor Ray, and let me make sure my microphone is on and people can hear me. Looks like you can. Okay, very good. So thanks again for inviting me to join the webinar, and thank you, all your participants, for attending. What I'm going to talk about today is agencies' voluntary restraints on their use of supervisory guidance, and in particular, the federal banking agency's adoption of an interagency statement on that subject, which they have stated is binding on them. So first of all, about supervisory guidance. A massive amount of regulatory agencies' work is carried on through supervisory guidance of innumerable kinds, rather than through regulations adopted through APA rulemaking. So what supervisory guidance is a document or a statement that sets out the agency's expectations for right behavior by its regulated entities, the guidance is expected to influence the conduct of the regulated entities. And where the agency has examination authority, it will be used by the examiners to assess what the entities are doing. Supervisory guidance is not legally binding. The objection to supervisory guidance, mostly from regulated industries, is that it puts forth agency power without having gone through the APA notice and comment rulemaking process, and that it is de facto mandatory, but not constrained by the processes of the APA. So the legal implications of supervisory guidance are recognized in court cases in two ways. So first of all, there is a set of cases overturning guidance documents that appear to be mandatory rather than merely guidance. And then second, there's a body of cases declining to review guidance documents because, not being legally binding, they are not final agency action. So that is their status in the courts. I'll talk about two examples of supervisory guidance, both of which originated in 2013. So first, there's a guidance by the Consumer Financial Protection Bureau on indirect auto finance, guidance that advised indirect auto lenders, those are lenders who provide auto loans through dealers, on how to avoid fair lending liability, specifically under ECOA, the Equal Credit Opportunity Act. This guidance was controversial because it was likely to constrict the financing practices of car dealers who are exempt from CFPB jurisdiction and are a politically powerful constituency. And in particular, the guidance would likely have resulted in greater lender monitoring of dealer behavior, and in particular, the practice of dealer participation, so-called, in which the dealers negotiate higher interest rates from their customers, which they then split with the lender. So that's the CFPB guidance. And the second that I want to draw attention to is the banking agency's joint guidance on leverage lending, which advised banks on the risks of loans with high leverage, such as loans that are used to support management buyouts and other corporate acquisitions. And this guidance was controversial because it constrained banks' ability to make money on high leverage financings and included a numerical threshold of debt to earnings. The statement also had what I would call a high level of prescriptive detail. The agencies put out FAQs the following year, that was 2014, emphasizing that the debt to earnings threshold was not actually a fixed rule. So those pieces of guidance were out there. There were industry initiatives in 2018 to get Congress to disapprove both of these guidance documents under the Congressional Review Act. And so the CFPB guidance on indirect auto lending was actually disapproved by Congress, so it's no longer in effect as of 2018. Congress ended up not taking action on the leverage lending guidance. And so the circumstances in 2018 suggest that this was a result of, well, I would call it a deal between the agencies and Congress. So the banking agencies did two things. First, they suspended their application of the guidance. And as a result, leverage lending increased, and so did public concerns about systemic economic risk. And second, the agencies committed to issue their interagency statement, and they did. So that statement came out in September 11th, 2018. It was the banking agencies along with the CFPB, and what it said was several things. So first, it reiterated that supervisory guidance is not legally binding, and that an agency cannot bring an enforcement action based on non-compliance with guidance. The agency is committed to limit their use of numerical thresholds or other bright lines. and said they would, if they did use them, they would make clear that they were examples only. And finally, they said that a financial institution will not be criticized by examiners for a violation or non-compliance of supervisory guidance. I emphasize that these are magic words, violation and non-compliance, so they suggest they would be used with legal mandates or legal rules and are therefore not appropriate for supervisory guidance. So those are the main things that that statement said in 2018. Later on, the statement was adopted by each agency by regulation. That happened in 2020 and 21. And this was a response to an industry petition. So industry asked that the statement be adopted by regulation. And furthermore, the regulations made the interagency statement binding on the agencies. So that's what the agencies did. And so those regulations and the interagency statement are still in effect today. And so one might ask whether the interagency statement has made a difference in the guidance practice of the agencies. And so I've taken a look at banking agency guidance issued in 2021. So not only post interagency statement, but after these rules have been adopted, which shows that the level of prescriptive detail in these guidance documents has declined, though I would say that the record is mixed, and I think the supervisory temptation to be prescriptive is strong. But I would say that important policy initiatives like focusing indirect auto lenders on how to avoid fair lending liability, or focusing banks on the risks of excessively leveraged loans, those are achievable through guidance that is consistent with the interagency statement. And so in particular, I think the CFPB guidance was fully consistent with the interagency statement. And so was the numerical threshold in the leverage lending guidance. I think that the attacks using those as examples, in particular, the attacks on the use of supervisory guidance tend to be attacks on the policy objectives reflected in them, rather than on their status as guidance per se. And so my conclusion is that I think the interagency statement does help keep agencies on the right side of the law, as expressed by the courts on the subject of guidance. And therefore it is supportive of the rule of law, and also that it does not prevent them from pursuing important policy objectives, that those objectives are, if they fall, are likely to fall as a result of political factors rather than legal. So that's my view. And so thank you again, Professor Ray, and back to you.
Great. Thanks very much, Chris. We're going to hear from Richard Griffin next.
Thank you very much, Professor Ray, and I'm very happy to be here and discussing this very interesting topic. I'm going to emphasize what I think is the differences in the nature and impact of self-regulation, depending on the way the relevant law is structured and the relevant agency is structured. And I'm going to use a particular issue, and I'm going to compare and contrast two agencies. And the issue I'm going to use is joint employer in the context of the franchisor-franchise relationship. And the two agencies I'm going to compare and contrast are the Department of Labor Wage and Hour Division and the National Labor Relations Board. So first, just a little background about the differences between the two agencies, and I'll start with the National Labor Relations Board. The National Labor Relations Board is the agency that was set up in 1935 to administer the primary federal law governing private sector labor management relations in the United States. And the agency has essentially two functions: adjudicating, investigating, prosecuting, and adjudicating unfair labor practices, and holding representation elections for employees to designate whether they want a union to represent them or not. And I'm going to focus on the unfair labor practice aspect. The board is the exclusive place for the adjudication of unfair labor practices. There's no separate private cause of action. On the other hand, the board has no independent investigatory authority. It relies entirely on either individuals, unions, or employers filing a charge to initiate the process for adjudicating the unfair labor practice. And that means that as a general matter, the board itself and the prosecutorial authority of the board cannot target a particular set of employers or set of unfair labor practices. You have to wait for the cases to come in. So it's a reactive agency. However, once a charge is filed, the agency has the exclusive authority through its general counsel, who's Senate appointed, or excuse me, presidentially appointed and Senate confirmed, to investigate, make a merit determination, and has exclusive authority over the prosecution of a complaint that is subsequently goes through an administrative adjudicative process before an administrative law judge and then up on appeal to the National Labor Relations Board, a 5-member appellate body, also presidentially appointed and confirmed by the Senate. So the decision by the board's general counsel, exercised through 50 offices around the country with regional directors and regional staff, to proceed on a charge by issuing a complaint and prosecuting the case, that discretion to proceed is unreviewable. The Supreme Court has decided that. It's a matter of decided law. If the general counsel decides not to proceed on an unfair labor practice charge, there is no place the charging party can go with that case. So I believe that it's very important in terms of the guidance and the prosecutorial exercise of discretion to understand that there's no option. And so I contrast that with the Wage and Hour Division of the Labor Department enforcing the Fair Labor Standards Act, where if you are enforcing the Fair Labor Standards Act and you want to bring a joint employer case against a franchisor and a franchisee, you can initiate, you have independent investigatory authority. You can target a particular industry, fast food restaurants, for example. And there is also a private right of action. So if somebody wants to file a class action against fast food restaurants on behalf of workers who have not been paid properly, they don't have to wait on the Wage and Hour Division. They don't have to file a charge with the Wage and Hour Division. They don't have to go through the administrative process. They can proceed independently, regardless of whether the Wage and Hour Division has issued guidance on the subject or not. Now, the courts will give a certain consideration to any guidance from the Wage and Hour Division, but there's a private right of action. And if the Wage and Hour Division decides to proceed, it does not proceed through an exclusive administrative process within the Labor Department. It has to go into federal court and pursue the case the same way that, that a private party would have to do. So with respect to the issue of joint employer, when I came in as the general counsel of the National Labor Relations Board in 2013, there were more than 200 pending unfair labor practice charges against McDonald's, alleging that McDonald's corporate headquarters was a joint employer, the franchisor, with the franchisees, the McDonald's franchisees. Similar issues were pending before the Wage and Hour Division when David Weil came in as the Wage and Hour Administrator. And he issued guidance on joint employer, and the General Counsel's Office of the NLRB litigated a case before the board, or weighed in on a case before the board on a broader joint employer theory than previously had been used by the agency. And so we both proceeded on joint employer cases, but we proceeded in different contexts. David targeted certain, and the Wage and Hour Division targeted certain industries, and he had to proceed sort of at the same time that private party class action lawyers were bringing wage and hour cases, while I proceeded, or the General Counsel's Office proceeded before the National Labor Relations Board to adjudicate cases that had been brought in by employees of McDonald's franchises who were trying to organize unions and who had been allegedly retaliated against. So the consequences of my decision to proceed on those cases, I couldn't target McDonald's. I had to take the cases as they came to me, whereas Wage and Hour could decide who they would pursue and what theories they would pursue, but they had to do it in parallel with the guidance, the cases being pursued by private sector counsel. So my point here is that depending on the nature of the agency, depending on the authority of the relevant decision maker, the consequences to a decision to proceed or not proceed on a certain theory can be very different. And I'll end on that note. Thank you.
Next, we're going to hear from Lyndon.
Thanks, Professor Ray, and it's good to be hearing the different perspectives outside of immigration law. And also at the outset, I just want to thank the ABA for the opportunity. I'm going to focus my remarks today on two aspects of the issue. First, share maybe at a higher level the considerations that I saw agencies factor in when deciding whether to self-regulate, and then talk a few minutes about a developing issue, I think, in self-regulation in the immigration space that's set for Supreme Court argument next month, and presents, I think, a novel issue in the immigration space. So let me start with the immigration. Immigration, probably pretty well known. It's a the statutes are hyper-specific. They're technical. They're long down to every aspect of controlling how millions of individuals come into the United States. And so for the most part, the vast majority of immigration law, there's actually very little discretion or room, even much room for agency interpretation, because Congress is so active in the immigration space under its plenary authority. However, there are a few provisions, and oftentimes it's just one sentence in the immigration system, where Congress has given the agency very, very broad authority through a single sentence. Having staffed the Senate Judiciary Committee, there is an understanding that this is a square peg, round hole environment, and that the agencies need that little bit of flex. And so there are some sentences, and some of those things are the secretary's ability to grant work authorization in his or her discretion. Broad, just that sentence alone. The secretary authority to extend someone's status. That's it. That's the only guideline in the statute. And the one that I'll talk a little bit more about is the authority to, technical term, parole, not in a criminal sense, but parole in immigration sense, which is to allow someone into the United States outside of the other legal categories. And that statutory provision does have a few constraints. It must be on a case-by-case basis for urgent humanitarian or significant public benefit. So there's three elements of that parole authority. I'm going to come back to that, put that aside for a minute, come back to that specific provision and how it's the struggles that everyone is facing on that issue. But when I was in an agency, I'll give a light touch to the mechanisms that my old agency used, U.S. Citizenship and Immigration Services. I suspect it's not that different than the other peers. They obviously did extensive rulemaking, and the biggest challenge at the Department of Homeland Security was not a desire to do rulemaking, but ultimately Congress's decision to put over 20 agencies under one umbrella organization, and it was a throughput issue that was often the limiting factor on the extent to which the agency could pursue rulemaking. But they also have sub-regulatory mechanisms, including adjudicators field manual, which I interpret as supervisory guidance that's directed internally. And then you would have directors' adopted decisions, which are not specified anywhere really in statute or regulation, but are informal supervisory guidance of how the director intends employees of the agency to apply similar facts. So there's nothing, I say that because there's nothing, I think, novel in the immigration space about how the agency, the tools that the agency utilizes, even if the terminology is different from other spaces. Having worn the hat as chief counsel, in terms of looking at the considerations of when the agency elected to self-regulate and provide specifics to those gray areas under the statute. The first was obviously litigation risk. Now, when I was there, it was still in the immediate shadow of 9/11. National security concerns were paramount within the Department of Homeland Security. They obviously still are today, but it was in an area of significant uncertainty by policymakers about the threat assessment at the government. And the decision of when you have these provisions of discretion, let's use the one I mentioned of whether to extend someone's status in the United States, very broad authority to exercise your discretion to say, we're electing not to extend this person's status because we might have security concerns about that. But that bumped up against a concern that should there be litigation surrounding your exercise of discretion, you were going to be in front of a federal judge who would not hesitate to put things in camera. And ultimately there was a concern, certainly by myself and within the legal divisions, that if you did not exercise that discretion carefully, because you knew it would be tested by another branch of government, that you would ultimately lose your authority when you needed to use that discretion and go to the judge under different facts. And so there was very much a respect for the judicial branch of your credibility when going into the court. Now, I think there's legitimate questions of the extent to which over the past few years that's been eroded or perhaps blown open under the prior administration in terms of pushing the limits of discretion and not really worrying about one's reputation before the courts. But at the time, and I think under this administration, certainly something that is trying to have that relationship with that level of review. The second was maybe not necessarily as appreciated on the outside of government, is just the operational capacity of the agency. So, your ability to exercise your discretion, let's use the version of work authorization, your ability to grant work authorization is somewhat dependent on your ability to issue those work documents. So the fact that you had authority didn't necessarily mean that the agency could do it. Now, the agency was fee funded, almost exclusively fee-funded agencies. So, they could say, well, we want to do something and ultimately we will get paid once we make this benefit available to the public. But you still had to hire and ramp up capacity and allocate your resources. And so the operational capacity was often centered to the discussions. The third was general public policy. There was an understanding within the agencies that certain areas where Congress had given discretion to the agency were sensitive matters that you had to take seriously. And one would be the Adam Walsh Act, as Professor Ray knows, where someone cannot get an immigration benefit if they may prove a danger to a minor or a spouse. And it's a very high bar. It's obviously it's an area of significant concern about potential abuse for people being brought to the United States, sponsored by family, spouses, to come to the United States, and concerns about trafficking and human abuse. Long-winded way of saying, if you get it wrong in exercising your discretion, there would be obviously serious harm there. And so adjudicators took that concern seriously. And in that space, the discretion was self-regulated through layers of supervisory review, which I would consider, hasn't been mentioned yet, as another way of reining in discretion, is by having those layers. And the last one, and then I'll shift over to the parole concept, is just losing the discretion itself, that Congress would not like how the agency had been exercising its discretion and ultimately rein it in, and the agency would lose that authority. And an issue that's timely today is back in the first half of last century, prior to 1950s, the government would use that parole authority to bring people in lieu of putting them through the refugee program. So when there was a humanitarian crisis, they used that discretionary parole instead of processing them as refugees, which has its own procedures to follow. Parole, as I mentioned, is discretionary. You can just do it right there on the spot. So the government did that at on a large scale basis in lieu of using the refugee program. And in 1980, Congress took that ability away. So now the government cannot use parole to bring someone in lieu of that person coming as a refugee. And we see the lack of that authority now constraining the government's ability to react in Ukraine, in Afghanistan. And that was a reaction to Congress to its broad use of that parole authority in the past. So that was always on the mind of government officials, which is, we might be able to use this, but if we lose Congress's support, we might go backwards. So the case that I just want to kind of provide a little bit of look ahead on is an interesting one. It's Biden v. Texas. It's scheduled for Supreme Court oral argument on April 26th. And it involves the Trump administration's policy of what referred to colloquially as the Remain in Mexico or Migrant Protection Protocols, which requires individuals to wait in Mexico instead of being in the United States and pursuing humanitarian relief in the United States. But one of the issues that the Fifth Circuit found was that the government's use of parole for so many individuals to come into the United States. So imagine you're at the border, you don't have sufficient detention space, you have a large number of people coming at the border. The government would use that parole authority on a case-by-case basis. There's no question about that. And it's obviously urgent humanitarian or public benefit reasons. So they're checking those boxes. But the Fifth Circuit found that the sheer volume of cases took it out of a case-by-case basis. How could it be a case-by-case basis if it's being used so frequently? And I raise that because the question of is there a numerical limit or a volume limit to the exercise of discretion is not one that I have seen in the immigration space. I can't speak to other areas where the fact that the agencies not only need to issue, for all those factors I mentioned, issue guidance about how they will self-regulate, but also need to now, if the Supreme Court decides in Texas's favor, that the agencies would need to factor in volume, and that their use of something at a high volume would create exposure, would mean it would be another area that the government would need to self-regulate to bring it back into that discretionary sphere. So it's a novel issue that we'll be watching. Former executive branch officials who tend to favor that executive authority are all weighing in support of the authority to use that discretion. And obviously Texas is fighting to say that's an inappropriate use of that case-by-case basis. It'll be interesting to watch. So with that, I'm going to turn it back to Professor and look forward to the subsequent conversation. Thank you.
Okay, great. We're going to now hear from Professor Steele.
Thank you, Professor Ray, for inviting me to participate today. And thank you to Ann Kiefer and other ABA staff in the section of Administrative Law and Regulatory Practice for all you all have done in order to put on today's webinar. I do want to start with a quick little disclaimer. The views that I am going to present today are my own and do not necessarily represent the views of any federal, state, local, territorial, or tribal government or any component thereof. So with that, I want to talk a little bit about enforcement priorities as a vehicle of self-regulation. Now, enforcement priorities and the setting of enforcement priorities are a fairly unique part of self-regulation, in my opinion, because the agencies do not explicitly say that they are not going to pursue something, or that they are going to change their stance on something, or that they are not allowed to pursue something as under their interpretation of a particular statute. Rather, in these instances, the agency is simply saying that other things need to be prioritized over certain things, right? We're going to prioritize X over Y. And the natural outgrowth of this is because the agencies have limited resources. If they are prioritizing X over Y, then they are basically self-regulating with respect to what they are going to do with Y, what they're going to do with Z, and so on. And so we typically see this come up in agencies with respect to things that they can control. So agencies, or at least the portion thereof that is very complaint-based, where you take your complaints as they come. You don't have a whole lot of control over what complaints come, how many come in one area, and when they show up. But other areas like directed investigations or compliance reviews, compliance audits, selecting which cases an agency is actually going to litigate. Those are areas in which agency enforcement priorities can be changed and shifted as a way for the agency to self-regulate. Now, this prioritization can come in many ways. It can take many forms. A lot of times it's simply, sometimes it can be announced, it can be communicated to agency constituents. Sometimes it can simply be communicated internally, but it can happen many ways. You can have prioritization in a particular area. I'm just going to give a random example. For instance, we are going to prioritize pursuing sex discrimination cases. Sometimes you can have prioritization within, or prioritization of certain issues within a particular area. So for instance, within the area of disability discrimination in schools, we are actually going to prioritize making sure that students with so-called hidden disabilities, so disabilities that are not obvious from looking at the student, things like ADD, ADHD, food allergies, diabetes, making sure those students are receiving the services they need. Sometimes it can be prioritization with respect to prioritizing investigations or audits of certain types of regulated parties. So you have a pool of parties that are regulated, but it may be that we're going to prioritize certain types. So for instance, maybe you target wage theft compliance reviews on employers who are in what are classified as low wage, high violation industries, instead of targeting all regulated employers equally. And again, this comes back to necessity. Now, there are many different reasons why an agency may choose to self-regulate through the establishment of enforcement priorities. But I think that all of them can be grouped under two primary umbrellas. The first umbrella is going to be a lack of resources. And then the second umbrella is just going to be political will. Now, agencies, of course, are relying on Congress for their budget. They're relying on Congress for their resources. And regardless of if Congress is feeling generous or not, the agency still has a duty. They have to fulfill whatever their respective mission is, regardless of what budget they are given. And so it's important for agencies to basically look at what they have, look at what all they have to do, and then set the priorities. But again, for everything you do, there's something you can't do, given your limited resources. And resources include not only your financial resources, but also your human resources. Now, of course, there's overlap there, right? Your financial resources can control, for instance, how many staff you have, but human resources may be limited for other reasons that have nothing to do with financial resources. It may be that you had, lots of staff who retired at the same time. And it just takes time to not only go out and hire, but to also onboard and train new staff. And so again, there's overlap between human resources, financial resources, but the cause of any type of lack of human resource or lack of staff is not necessarily always related to financial resources. And then finally, you have time. you have a certain amount of time in order to do things. Of course, many agencies have standards by which they aim to complete, for instance, investigations in a certain amount of time. They aim to complete them in 180 days or something like that. It may be that you have a limited amount of time before the leadership of the administration changes. And of course, with new leadership typically comes new priorities, new perspectives on things. But limited resources is one of the reasons where agencies may self-regulate, not because they necessarily want to, but they feel as though given what they have to work, given the tasks they have to do and what they are, the tools they have to do the task, they may feel that they have no choice but to self-regulate. Basically, almost like a Hobson's choice for agencies. You have instances in which the agencies are regulating through prioritization, given the needs of the individuals that the regulations are supposed to protect, including the prevalence of certain types of conduct that the agency sees as harmful. So for instance, let's say for years, you had Title IX enforcement, Title IX technical assistance and training that has been focused on equal athletic opportunity in schools. For years, every time, lots of people heard Title IX, they automatically thought athletics. And so it may be that your regulated parties, your school districts, your colleges, your universities are more compliant in the area of athletics because there's been a focus on it previously. And so they may be more compliant with respect to Title IX athletics than they are with respect to Title IX provisions concerning pregnant and parenting students, or Title IX provisions concerning the equal provision of STEM education. And so it very well may be that the needs of the regulated party or the needs of the individuals, in the case of education, the students, in the case of labor and employment, your employees, your employers, it may be those needs dictate what the priorities are. But again, this all goes back to a lack of resources. Ideally, the agencies will be able to do it all. If they had the money, if they had the time, if they had the staff to do it all, but they simply don't. And so again, sometimes this self-regulation through enforcement priorities is a self-preservation mechanism. It is born out of necessity. For every training you do for pregnant and parenting students, that's one less you can do for athletics. You also have politics. And politics plays an important role here. Most of the staff in agencies are not considered political appointees. They are civil servants. They are there across multiple administrations. But as administrations change, you have perspectives on certain issues that change as well. And so it may be that an agency may decide to focus on an issue because it believes, or to prioritize an issue because it believes that the leadership of a previous administration neglected that particular issue. So for instance, it may be that an agency decides to focus on disparate discipline in schools on the basis of race, because it feels that in previous years, the agency has not focused on that so much or has neglected that issue. And it may be because of the priorities of the previous leadership of that particular agency. But politics can also, as we know, cause obstacles for agencies and put hindrances in the way of effective, efficient enforcement of whatever statute it is that the agency enforces. And so with respect to that, it may be that an agency is going to self-regulate and start focusing on issues that it views as politically palatable. So for instance, disability comes to mind with respect to any type of work in anti-discrimination. Disability, whether it's in schools, workplaces, or transportation, is, an area with fairly broad bipartisan political support. And so because of that, it may be that the agency is going to focus on that because they view that if they did that, they would not be spinning their wheels. They would not have so many obstacles that are brought up towards the end of any type of audit or investigation, because there's fairly broad political support for it. And so lots of different reasons lots of different ways agencies set enforcement priorities, but that is one way to regulate. And probably the most unique thing about it is that you're not saying, the agency is not saying it's not going to do something. It's not saying that it doesn't have the power to do something, or that it doesn't have the desire to do something. Rather, the agency is simply saying something else is more important right now. And that gets into, and that can be helpful when it comes to things like judicial review, which I'm sure we will talk about later. And so with that, I'm gonna turn it back over to Professor Ray.
Great, thank you so much to each of our speakers. We got some examples of agency self-regulation in a wide range of regulatory areas, and some discussion as well of kind of agency incentives, what factors might lead an agency to adopt these measures, and what some of the barriers might be. I want to take a few minutes to invite the panelists if they would like to follow up based on anything that was said in the presentations, either posing a question or making a comment.
So I have a question for the other panelists, and in particular, those who are active in immigration law. And so I guess that would include you, Professor Ray, is to what extent do you see the litigation of the last few years over programs like DACA and DAPA as cutting back, if it does at all, on agency enforcement discretion as recognized in earlier court cases, notably Heckler versus Cheney in the Supreme Court?
Lyndon, do you want to take an initial opportunity to respond?
I'm a little nervous speaking in front of you on this. I think you're going to have some good thoughts. I think, absolutely. I mean, first I want to echo what Professor Steele mentioned about enforcement resources. There has never been a time ever that I'm aware of in the immigration system where there has been resources in line with legislative mandates, and just start with that baseline assumption. So you come out of the gates with this disconnect, and you can whether you trace it back to difference between authorizers and appropriators, or just a lack of thought about it, but where you operate in an environment where it is impossible to fulfill what even the folks who say you should be doing from an enforcement perspective, it's impossible to do that because you don't have resources. So then as an agency, you're in that environment, we're trying to figure out how to get the best thing done with what you have. And I do think what we're seeing right now is, and then I'll turn over the mic, is that the biggest thing that I see right now is the speed. So not only is there litigation and challenges to how the agencies are deciding to utilize its enforcement authorities and resources, but the litigation is slowing things down. And that is, of course, an end in and of itself, if you can tie up in administrations. And we've seen it both directions. We've seen the litigation to slow down President Trump's efforts to ratchet up the enforcement tools. And then we immediately saw states suing to stop President Biden's efforts to direct the agencies to deploy their resources arguably more narrowly in that enforcement scheme. And both then are in this kind of no man's land then for the field. And the agency has to operate in an environment where that guidance is hung up as it works its way through the courts. And that's really that's not a good public policy to have no guidance out for enforcement officers, because it is in and itself a policy decision itself then to make an immigration enforcement officials in essence free rein because they don't have anything in place. So I don't know, Professor, if you wanted to speak further about that.
Yeah, I think, Chris, I think we spoke also last week sort of about your broader point that, what is sort of the status of Heckler versus Cheney in light of the DACA and DAPA litigation. And today I would add the various district court decisions that have preliminarily enjoined enforcement priorities, the Biden administration. I think it's certainly seems like it's a much more uncertain environment than maybe a lot of us thought it was with respect to the status, the reviewability of these guidance documents. I think it'll be interesting to see whether that approach to guidance migrates outside of immigration. And I don't know if any of you have seen any evidence of that. Be interested in your thoughts.
I actually had a slightly different thought that I wanted to respond or raise with Lyndon when he was talking about volume exercise of discretion and what role guidance from the agency leadership plays in making sure that that discretion is exercised within certain cabined criteria, so that essentially, to your point about if the guidance isn't in place, you have a bunch of people around at various initial points of decision making who are exercising discretion without guidance, so that you have the possibility that like cases will be treated very dissimilarly. And I think one of the functions of guidance at the National Labor Relations Board, from the General Counsel's office to the regional offices, is to make sure that charging and charged parties, when they go into a Seattle regional office, will be treated the same as they will be treated in a New York regional office. You have to walk a fine line between not hamstringing the exercise of the person who has all the facts and circumstances in front of them. But there are ways to do that where you give guidance and then you provide for the review internally of the exercise of discretion at the local level. The way it works at the NLRB is that if the regional director decides not to issue a complaint, the charging party can appeal that internally to an office in the General Counsel's office. But I wonder if you could sort of address that particular issue about assuring that discretion is exercised consistently, both because you want it to be defensible when it ultimately gets challenged, but also because you have an obligation to provide similarly situated people with a similar result.
Well, I think pulling on real world situations, so Afghanistan, individuals who had to leave and be brought to the United States on short notice through that parole authority were applying from different locations around the world, in very remote locations, different countries, but all coming under that standard that I mentioned earlier of what constitutes significant public benefit and those risks. And so I'm not sure if it's directly responsive to your question, but that is a significant question. But the agency is about the idea that you do want similar cases reaching similar conclusions. It's very difficult to defend, especially in the public's eye, why someone might be brought to the United States under one fact pattern, someone else is denied. That's a difficult, even when it's discretionary, courts are going to have a lot of questions, and of course the public opinion. But as y'all mentioned, all of y'all mentioned, is if you go too far though in prescribing that how they are applying their discretion, the likelihood of an APA challenge increases, that you fail to follow the APA procedures, that you've now put it into a regulatory rule as opposed to an exercise of discretion if everything comes out. And that was also the balance. And where that line was, very difficult to tell. Certainly when I was inside the government, from the outside, it's even murkier.
Right, so we have a question in the chat. I don't know if the panelists, if you can see it. And I would encourage participants who are still with us to please feel free to type a question for any of the panelists or a general question for anyone. So I'll read it out. Just the first question is, when an agency is exercising authority based on, quote, gaps in law, which Congress did not speak to expressly, where it's not clear that the agency is restrained by statute, how important is the building of administrative records in support of exercising that authority?
So let me kind of make a preliminary observation about that. And so there are different kinds of discretion. So if the statutory gap is one in which the agency's discretion is not dictated in a particular way by the statute, but it is within the zone of what the agency is supposed to be regulating. So that's very typical kind of supervisory discretion exercised by an agency, and I think would fall within the APA standard of review for abuse of discretion as interpreted by the Supreme Court in the State Farm case. And so in cases like that, the building of an administrative record is very important. And in many cases, the agency's decision will stand or fall based on the quality of that record. If we are talking about prosecutorial discretion, which is a type of discretion that under Heckler versus Cheney is absolute and not reviewable, then I think the administrative record does not matter.
Okay, we have, I don't know if anyone else wants to add to that. If not, we can go to the next question. Great. Okay, so this is a question for Richard. Given DOL and the NLRB were both enforcing cases against McDonald's at the same time, did any of those cases reveal different legal standards, conclusions, or findings between the two agencies?
Well, I want to be clear that I was talking generally about the franchisor-franchisee relationship, and that can change depending on the two, the nature of the franchise agreement, and that DOL was largely looking at fast food generally, and we specifically had a series of cases against McDonald's. But the relevant thing there was that there's very different definitions of employer under two statutes. Originally, the National Labor Relations Act standard was interpreted by the Supreme Court in a case involving the Hearst Company back in the 40s, that the board could take an economic realities look at the relationship between the parties and determine whether or not one putative joint employer, based on the economic reality of the relationship between the terms and conditions of employment of the relevant people, whether that was enough to make the entity, in that instance, the parent newspaper company, a joint employer. The law was amended in the Taft-Hartley Act to make it clear that the board had to apply the common law of agency to the employment relationship. So the board is constrained by the common law of agency and is not due much, if any, deference in how it interprets the common law of agency. Courts feel perfectly comfortable interpreting the common law of agency and don't give the board much discretion in that regard. On the other hand, the Fair Labor Standards Act has a very, very broad definition of to employ, which is suffer or permit to work. And it's much broader than the common law and has been held to be much broader than the common law by the Supreme Court. So they're really different tests for joint employer under the two statutes, and that can result in different outcomes.
I had a couple of questions that I'd be interested in hearing your thoughts on. So we've talked about kind of these measures that an agency will adopt, and we're all aware that with the change of administration, of course, agency leadership can change, and so the policy objectives and kind of even the understanding of the agency's mission can change in somewhat dramatic ways. So I want to talk about this issue of sort of the durability of self-regulatory measures. What are some things, I guess, that an agency can do to kind of cultivate. So other than issuing a legislative rule instead of guidance, what are some things that that can be done, sort of maybe softer measures that can be undertaken to kind of promote the durability of some policy choices that are made? And should they? I mean, maybe the idea is there really shouldn't be any kind of stickiness.
So I'll jump in first here, and short answer is it depends, right? Like you want it to be durable if you like the policy, and you don't if you don't like the policy, right? And that's just how it goes. But I do think, now that said, I do think it's important for the agencies to have some flexibility, particularly when you're talking about priorities. I mean, even if you just look at a household budget, what you need in the year 2020 is not necessarily what you need in the year 2022. What you are going to prioritize changes as well it should. And so flexibility is important, but that said, so is stability and notice, right? If you have told your regulated parties, this is what I'm going to do, this is how I'm going to do it, this is what I expect of you, to have these sharp turns where you change that all of a sudden after the regulated parties have invested capital and infrastructure and resources into training and things of that nature, to make a sharp departure from that in some cases can be very unfair to them. And so I think notice is incredibly important with respect to just simply being fair to the parties who are being regulated by this. So as far as the stickiness of the regs, sometimes it's a good, or of the self-regulation, sometimes it's a good thing, sometimes not so much of a good thing. I'm typically always going to come out in favor of flexibility because of course times change, things change, technology changes. But I do think to have sharp, abrupt terms whereby you have not given either the regulated parties themselves or the attorneys who represent the regulated parties ample opportunity to prepare, to advise their clients, things of that nature. So in other words, when the regulated party is finding out there was a change, when they're getting some type of notice of violation, I think that can be problematic.
So this is an issue that the National Labor Relations Board has been front and center in terms of the criticism. It's typically characterized as the board's flip-flop, or more nicely stated as policy oscillation. But one of my predecessors used to say, well, to Professor Steele's point, where do you want it to stop, on the flip or on the flop? And that goes to the point that some people like certain policies and some people don't. But to her point, and one which I agree with very strongly, there needs to be notice to the parties. And it's particularly difficult at the NLRB, which has a history of adopting rules of general application through case-by-case adjudication. So there's two ways to address it. One is to adopt more rules of general application through notice and comment rulemaking, which the board has moved in the direction of recently. And the second is that if you are contemplating, in the case of in an adjudicative situation, changing a rule of general application, that before you do it, you give both the parties and the general public and interested parties the opportunity to file amicus briefs and address the situation. The current board leadership feels very strongly that if it's going to change a rule through a case, it needs to notify, send out a notice that it's contemplating that, and receive broad briefing. And so, but that doesn't stop the criticism of the policy oscillation.
So just an observation about that. And so all of that is completely true. So I would say that there's a fairly large body of law, including in the Supreme Court, that agencies can change their minds. And in particular, they can change their minds when the administration changes. And so the State Farm case resulted from a change in administration. The Chevron case resulted from a change in administration, many others. So agencies can do that. There is an element of fair notice. So where an agency has been acting through regulation, there's a significant body of law that the change in agency opinion has to go through APA process for changing the regulation. That's what the fair notice is about. And so at a kind of a black and white law level, those flip-flops can continue to occur administration by administration. I believe that there is some tendency in the Supreme Court to get impatient with flip-flops eventually and think that something is wrong here. And so there was a Supreme Court case in recent years. I don't remember the name or the specifics of the case, but I believe it was about the status of particular people as employees or not, and how they were compensated, which was something that had changed for this particular category of employees, which might have been something to do with, the finance managers and car dealers, something like that. And that had changed repeatedly over the decades, and the Supreme Court ultimately laid down the rule of law of what they were under the statute. So no more flip-flopping. And then another case where I'm not sure that's happened yet, but I think is ripe for it, is the status of net neutrality, which you may recall depends on the FCC's interpretation of a key provision of the Communications Act, and in particular, whether internet service providers are common carriers or private carriers. And so that's a decision that has flip-flopped as the administration changes. It is an interpretive matter, which under the Chevron doctrine, it is up to the agency to decide which it's going to be. And so it can change administration to administration. But I'm not sure that the Supreme Court ultimately is going to agree, and it might, in fact, throw out Chevron deference along the way.
To your point, Chris, there are a number of instances where the Supreme Court has upheld an agency decision stating that it's within the realm of the agency's discretion to decide. And then there are other, and I'm speaking again with the respect to the statute that I'm most familiar with, the National Labor Relations Act. Then there are cases where the court has said definitively, this is what the statute requires. And it's pretty clear that there's no ability to flip-flop where the Supreme Court has definitively interpreted the statute. The area where the Supreme Court has approved one view, but has said that view is, within the agency's discretion, and certainly it can change. Classic example is with respect to employees' ability to resign from a union. 4 justices of the Supreme Court said it was required that they be able to resign without any limitations. 4 justices said there could be reasonable limitations on that. And Justice White said, either way is fine with me, and it's up to the agency to decide. And that case, Pattern Makers, is a classic example where it turned on one justice's view that it was discretionary within the agency.
Right. Okay, I have a couple of points to follow up on, but I want to address this question in the chat. So the blurb for the panel contrasted agencies that, quote, engage in robust self-regulation and others that hardly ever do so. What are some examples of the latter? Right. So in conceiving of this panel, of course, my attention is often on the immigration bureaucracy. And although we've talked about examples of self-regulation, enforcement priorities in particular, I think there's actually very little in that part. I don't know if Lyndon would disagree, and I know that you weren't on the enforcement side, but it seems like a lot is simply left to kind of line officer discretion a lot in terms of if someone's, granted a stay of removal, if someone's, an immigration judge can decide if a case is administratively closed. And, there's all sorts of points along the process of removal where that can be stopped. And it's usually in the hands of a low-level official without a lot of guidance on how to make that decision. So I think in my mind, that stands out as an agency where there's maybe less than in other agencies. And of course, the question then arises, well, why is that? And it's an interesting question. I think it might have something to do with the nature of the regulated parties. So, Chris spoke about kind of regulation, that this interagency statement, that it sounded like, regulated parties were sort of pressuring for some limitation on the use of supervisory guidance, and they got it to some extent, if that's a fair characterization. Whereas if you're talking about immigration enforcement, you have sort of people who are definitely not part of the electorate and relatively powerless, even among that community, right? People who aren't, they're not on the sort of benefit seeking side. They're on the other end. And so I welcome others' thoughts on these issues too, of sort of what explains some of the differences across agencies. And it may be more specifically, I guess a question for Chris, would you agree with the characterization of kind of regulated entities and parties sort of demanding self-regulation?
So I absolutely would agree with that. And I think it does make a huge difference exactly what you were describing about the level of power and influence of the regulated constituency within the society. So in the instances that I was talking about, the car dealers are a politically influential constituency. They can go talk to their legislators. Large banks are a politically influential constituency. They can go talk to their legislators, which is exactly what happened in the case of these guidance documents that I'm talking about, and did result in the adoption of the interagency statement on the role of guidance. Those constituencies were, I think, taking advantage of kind of a fairly short window of action under the Congressional Review Act, where if you have all three constituencies of government, House, Senate, and the White House in the same party, and you're within the Congressional Review Act window of review, generally following the change in administration, that's when you could strike. Outside of that context, even for these influential constituencies, it can be more difficult, although they still have, lots of levers that they can pull and talk to their, friendly legislators and have the agency's heads hauled in for hearings. If the agency is an appropriated agency, then the budgetary process is a heavily political process, and a lot of pressure can be brought that way. Not the case with the banking agencies.
A couple of other questions in the chat. So, all right. So you touched on it previously, but could you elaborate on what are your opinions on what legal obligation, if any, there is for an agency to publicly announce non-enforcement policies or a change in an agency's enforcement priorities where regulations are not being repealed? So the obligation to, I think, provide notice of a change in enforcement priorities or to announce non-enforcement.
So where you are not repealing any type of or changing any type of regulation, I'm not so sure there is much of one. Now there is a requirement that individuals be given notice, and so it very well may be a situation where your new principle, your new stance on the issue will not be appealed by a court because you failed to give that notice. And that's where a court could actually review it. But it may be that it's not going to be appealed because you failed to give that notice. What typically happens is where there was a public pronouncement of the enforcement priorities, and there's not always a public pronouncement. Sometimes it's just an internal memo to staff, but where there's been a public pronouncement, when that changes, there will likewise be a public pronouncement of the change. And that can come a myriad of different ways. You can have dear colleague letters issued. You could have some type of interpretive guidance issue. You could have changes to changing an agency's FAQs on their website, or changing a web page on the broader agency's website. You can have someone who's in leadership kind of go on the speaking circuit and explaining the new priorities of the administration or the new priorities of the agency. And so there are lots of different ways that it can be done. And again, sometimes, or typically, when there's a public pronouncement one way and that shifts, you do have a public pronouncement another way. Sometimes it can be coming out and say, hey, we previously focused on X, we're no longer going to focus on X. Sometimes it can be say, just affirmatively stating we will be focusing on Y. And if they're focusing on Y, then X is not as high of a priority. So with respect to specific legal obligations, I would imagine that would vary from agency to agency. But with respect to trying to hold a regulated party's feet to the fire, when you said you were doing this and they are in compliance with this, they're just not in compliance with the new thing where you have changed your mind and not told anyone that you have not changed your mind. Sometimes that can be problematic with respect to enforcement, and that can happen lots of different ways. Sometimes it can be a situation where a regional office decide something and sends it up, and if the decision was at the regional office, and typically it's not, because you do want to, we've already talked about having some type of uniformity amongst the entire agency, but sometimes it can be where some party outside of the agency has some level of review, and they simply are saying that you didn't put this regulated party on notice that you had changed your mind. And then outside of a legal obligation, you also have legitimacy, right? Agencies want to avoid having this perception that they are a gotcha agency, that they just want to get you at all costs, that they want to trick you, that they want to hide the ball. And so there is something to be said for legitimacy. If you are truly there to help regulated parties comply, compliance is a good thing. And so you want them to know what it is they need to be complying with, and how you all are going to assess whether or not they are compliant. And so it's outside of the legal obligation, there's also that legitimacy piece.
Right, there's one more question in the chat if we have time to address. So have we talked about examples where agencies self-regulate to provide greater protections than even the Constitution would require? So for example, the limited approval of government-funded counsel in some removal cases, so and in immigration enforcement. I will add to that question and just sort of, I think it's a really nice point that raises kind of this question of who benefits and maybe who loses out in agency self-regulation. Of course, it's going to depend on lots of factors, what the agency is about, the statute, and what the actual self-regulatory measure is. But you could imagine where regulated parties could typically benefit from this kind of measure. Lyndon, I don't know if you want to address, since it sort of brought up limited government-funded counsel in removal. If you have other examples, or if you want to react to that.
Well, it's a controversial question from a public policy perspective, but setting aside that, I'll just share the thinking on why the government has at times in the immigration space elected to self-regulate, provide more protections beyond what the law might require. And that's when it does actually further the government's own purpose by ensuring that those parties understand the process that they're going through, that the regulated parties have more confidence in the outcome of the decision. There have been some studies that show parties are less likely to appeal and challenge the government decisions if they have a lawyer advising them of their likelihood of success and difficulties, and perhaps even detention as they pursue that process. So there's certainly an aspect of goodwill towards the public when they're making that decision, particularly when you're talking about minors and others going through the process. But you would be remiss if you didn't view it through the lens that there are times when it's in the government's own interest to provide those services, even as they are perhaps pursuing an enforcement action, again, because of the resource implications in the system.
So I would say that as a generalization, agencies providing from a procedural perspective more protection than the Constitution requires is an everyday occurrence. So in the case of financial regulatory agencies that I'm familiar with, all of those agencies have enforcement regulations that are procedural regulations and set forth enforcement procedures with considerable detail and specificity. And so, in my opinion, probably more, and then maybe a lot more than what the Constitution requires, which, to take the words of a Supreme Court case, is some kind of hearing. So the advantage to the agencies of doing that, I think, is that it makes the result legally more robust and stronger against challenge. So it's in their interest to do that, as well as, of course, the interests of the regulated entities to make sure that they have a fair procedure.
Do you want to follow up? I wasn't sure.
I was thinking about it. I'm not.
Okay. Not to
my-
put you on the spot.
Yeah, I'm not sure my point is 100% relevant, but there is no discovery, generally speaking, in NLRB administrative proceedings. And yet the board has adopted a rule that if a witness is put on who has given an affidavit as part of the investigatory process, after they're testifying, the affidavit is turned over to the other side for use in cross-examination. And I think that that's an example of a procedural requirement that the agencies adopted that is by no means required by the Constitution, but is designed to assure a fair and defensible outcome.
Yeah, and I guess a quick final question for all of you. Understanding that the desirability of particular measures are, of course, going to depend on your substantive policy preferences. So that aside, what are some things that can be done within an agency to promote self-regulation? Even the production of the kind of measures that that we've been talking about, where there may not be pressure coming from regulated parties, or at least pressure that's cognizable to the agency. To what extent, I guess, can leadership and culture matter? And just any this is sort of a moment for creative ideas. And I'm just curious about your thoughts.
I think this is crucially important. As Professor Steele pointed out, the vast majority of the people who work in these agencies are career employees. And so my view is that one thing leadership of whatever political stripe can usefully do is get input from the career people about their suggestions on how, for example, to better enforce the law, or how to better treat parties before the agency. And again, at the NLRB, there was always a best practices committee that had career staff from the regional offices that largely was responsible for the adoption of most of the procedures for hearings and investigations that the agency lives by. So I think it's very, very, very important. Also, because you want to have career staff buy-in on whatever the process is. And absent that, you can waste a lot of time with lightning bolts from Washington that nobody pays any attention to. So I think regular engagement with the career staff and really listening to what is almost always their much better ideas than what you have is a very, very important part of any good institutional culture in a government agency.
Great. Any final thoughts from any of our panelists?
I want to echo what was just said. I think that buy-in from the agency parties, which of course starts with getting their input on the front end and their expertise, it also goes to that question of the durability that you talked about. And if you want to have durability of a particular self-regulation, and ensuring that you've got it they understand your thinking and the buy-in, and it's been improved because of their expertise, is more likely to have full implementation. And of course, it's also going to be better defended against challenges at every level and fewer weaknesses for opponents to attack it.
And so I think that having listened to what the panelists have said, I think durability can be achieved in a couple of ways. One is by putting something in a regulation that has to go through notice and comment exchange. Not all regulations do. So regulations of internal agency practice, which these might be, don't. And, you know, there are examples of that, which time does not permit going into. But the other is listening to what everyone's been saying about fair notice. The more public an agency position is, the more political and legal difficulty there might be in changing it quickly. And so taking those things together, I think we've seen that in the change in administration between Obama and Trump, there were a lot of instances in which the Trump administration tried to change things quickly and lost because the courts held that APA processes were not being followed.
I want to thank all of you, the attendees and the panelists, for what to me was a very interesting conversation on an important topic. So thanks again for your time, and hope we'll have a chance to chat again. Thanks.
Thank you very much. Appreciate it.
Thank you, everyone.
Yeah.